Okay, let's get started. Hi guys, welcome to today's SCO live update. We're going to be talking to you about two cases today. The first was before a bench led by Justice S.K Kaul called Ghazi Salahuddin versus the state of Maharashtra. This is a petition that's seeking the recognition of Dalit converts to other religions. It's seeking the petition seeks for them to retain their status as Scheduled Caste for the purposes of reservations. The petitioners claim that despite converting to a different religion, a lot of the social stigma is still carried with them, and a lot of the reasons behind reservations that justify reservations in order to create a level playing field, such as creating a level playing field in situations like education and public employment. Those factors do not change at the point where someone from a scheduled caste converts religion. All of these are still carried with them. It's just that their religious identity changes, and the petitioners are claiming that to deprive them of their scheduled caste status counts as religious discrimination. The union government for their part is claiming that this is a policy matter and that a commission of inquiry has been constituted in order to examine this. But the petitioners are not buying this, in part because this case has been pending since 2004. It's been 19 years since the petition was first filed. They also claim that in 2007 the Justice Ranganath Commission found which did an empirical study on this subject. Their conclusions were very similar to what the petition was claiming was true, and their conclusion was that SC status should be extended to Dalit converts to different religions. The union, for its part, at this moment is claiming that they do not accept the findings of the Justice Ranganath Commission. They haven't explained why yet. Presumably that will come up in later hearings. But as of right now, the union is claiming that they're not accepting the Justice Ranganath Committee's findings. Nevertheless, the petitioners are claiming they have a bevy of empirical data to justify their stance. This case has been posted for later this year and sometime in July. And we'll have more on it then. And it's going to be posted for following the summer vacation. And the Supreme Court will not hear it in the first instance. The Supreme Court will not hear it in its entirety, but they will decide a schedule for hearing it. They will probably hear it over at least 4 days. Both sides claimed that they will need at least 2 days to finish their arguments. On the other hand, we have the Constitution Bench case that ended today on the group of companies doctrine. Today, the respondents finished their submission and continued to walk a fine line of not rejecting the group of companies doctrine, not saying that, which states that the group of companies doctrine briefly allows non-signatories to an arbitration agreement to be roped in and made parties to any arbitration that arises out of a dispute if they have a legal relationship with one of the parties and there is a transaction that concerns them. Today, senior advocates Nakul Diwan, Meenakshi Arora, and A.M. Singhvi, who are all representing the respondents, continued walking the fine line that the respondents have been walking for the last 2 days, which is to say, along with senior advocates such as Darius Khambata, and they have claimed that while they are not directly opposing the introduction of the doctrine, they are in favor of strong limitations upon how the doctrine functions in the Indian context. For example, yesterday, senior advocate Darius Khambata argued that the doctrine should be subservient to the doctrine should be adopted, but it should be subservient to all the provisions in the Indian Contract Act based on their standards for acceptance, for performance of a contract, in order to determine whether a non-signatory can be roped in. And today, for example, senior advocate Meenakshi Arora argued on the concept of implied consent, and said the court will have to look into whether non-signatories have taken part in negotiations, have made representations that about something in the agreement that exists that they may not have signed, but that they may have participated in a related transaction with. The senior advocate A.M. Singhvi came and talked about how there is a subjective and an objective test to see to determine what the true intent of a party is, to see if a party truly intended to be a part of this transaction and wished to be, and in such a way that they should be roped into any arbitration regarding that transaction. He's highlighted how essential party autonomy was, and how if the doctrine is not handled with deft hands, correctly, delicately, a lot of the principles of party autonomy will go out the window, and we create a dangerous situation where parties can be roped into arbitration proceedings without necessarily being involved to a great extent. Finally, Advocate Hero Advani appeared and said, and building off of his arguments on the first day of hearings, he's in favor of introducing the doctrine. He built off his arguments to say that a lot of the respondents' arguments weren't necessarily relevant in this case, because it is not the court's primary duty to deal with a lot of this. The court should only be dealing with this at a very surface level, and that arbitral tribunals would be the ones who would apply the group of companies doctrine. The court's job here was only to recognize whether it was applicable or not. The arbitral tribunals will recognize the group of companies doctrine. They will take it forward and decide how the doctrine evolves in the Indian context and how it will affect non-signatories. Whereas the Supreme Court is mainly concerned with challenges that come from these arbitral tribunals, and the off chance that one of the parties in these cases does not want to be involved, then these cases will be referred to the Supreme Court or a High Court, and they will decide whether the group of companies doctrine was correctly applied and these third parties were roped in correctly or not. That's it for today's update, guys. I hope you guys had one. I hope this was informative for you, and we'll see you tomorrow. Bye.